All right, welcome back. I hope I've got a good one for you today. I'm going to try to keep it short. Frankly, it's a short filing, but we'll see how exasperated I get with it, because that will be the determination of brevity. So today, what have we got? Well, first we've got a real quick update on the Floyd Wallace versus Las Vegas Metro Police Department, the News Now Omaha lawsuit, and then we've got a master class in legal filings from Delete Lawz himself. And I've only briefly looked at his filings, so it'll be mostly a reaction as opposed to just recitation. So, with that, let's jump in to the material at hand. So, for News Now Omaha, we had an order on the 25th of May. Apparently, Floyd has not paid his filing fee, and he also has not applied to proceed in forma pauperis. So the judge ordered that Floyd must either make the necessary arrangements to pay the filing fee, accompanied by a copy of this order, or file a complete application to proceed in forma pauperis. The clerk of the court shall send plaintiff the short form application to proceed in forma pauperis by a non-prisoner. Plaintiff must comply with this order no later than June 22nd, 2023. Failure to comply will result in a recommendation to the district judge that this case be dismissed. And it was signed by Magistrate Judge Nancy J. Coppy. So, as you know, I don't watch Delete Lawz. I understand, though, that there might have been a fundraiser to raise the filing fee for Floyd. Um, well, that might have been fraud, by all indications, if that did happen. So that's the fun update on that one. Moving on. So the update on, well, the Delete Lawz masterclass in legal writing, I should have specified earlier, is in DeCastro versus Abrams, the Massachusetts case. And yikes. So, looking at the docket, just as a refresher, so the case was filed September 2nd of 2022. That this is going to be important. Scrolling. They answered on November 7th, resulting in his conniption fit about, well, I dismissed the claim, but it was just him playing games. So let's find it. Amended complaint, November 16th, 2022. You'd think I didn't scroll through this right before going live and look for all of this, but let's see. Where is the supplemental complaint? Okay, supplemental complaint, December 2nd, which I believe is where he added Google, even though that's not how you add Google, but either way. And then he filed his motion for leave to file a second amended complaint on January 11th. February 2nd is going to be an important date. There are actually filings that his motion to strike and basically the whole motion for contempt nonsense. And so that was all on the 2nd of February. And finally, we have the second supplemental complaint on April 24th. So that's basically the important filings thus far. And then, of course, so on the 23rd of May, Google had a flurry. We did their motion to transfer the case to Northern California, or in the alternative, to dismiss. And we also had the motion for attorney Benjamin D. Margot to appear pro hoc vice, which I told you was a formality. It was a formality. Judge Burroughs granted it the next day. And so today, we are looking at Delete Lawz, opposition re 121, motion to transfer case to Northern District of California, and in the alternative, motion to dismiss for failure to state a claim. So this is actually a fairly short motion, but he's condensed 30 pounds of BS into a 5-pound sack. So it's at least from what I've seen. Like I said, I have not read it. I've only skimmed a little bit. So as I said, in DeCastro versus Abrams in the U.S. District Court for the District of Massachusetts, and it's titled Opposition to Defendant YouTube Google LLC's Motion to Transfer to the Northern District of California, or in the alternative, to dismiss. Introduction. Plaintiff Jose DeCastro offers the following response to defendant YouTube Google LLC, YouTube or defendant. Motion to transfer case to Northern District of California, motion to dismiss for failure to state a claim, ECF number 121. In support of this response, plaintiff submits a memorandum of law, which is fully incorporated herein. Points and authorities. Plaintiff did not agree to sue in the Northern District of California. A little advice. This bold, that should be your section title caption. You do not proceed on the same line into the body. That this is bad. This is bad formatting. Not that it matters all that much, because when you're dealing with morons, frankly, you should be surprised that they're able to write. YouTube has clearly not yet read the first amended complaint, ECF number 62, and the first and second supplemental complaints, ECF numbers 79 and 118, brought by plaintiff in this action. This action is not regarding any agreement between plaintiff and YouTube. Yeah, for starters, I guarantee they have read all of those complaints. It's their job to read those complaints. It's their job to respond to those complaints. The problem is, now stick with me here. The problem is, if the complaints are so incomprehensible that you don't know what they're about, number one, that means you have failed to state a claim upon which relief can be granted. But number two, it doesn't mean you get to bring the snark saying they clearly have not read the complaints. Maybe they didn't understand what you were getting at, but that's on you being a poor writer, not on them being a poor reader or not reading, period. And this action is not regarding any agreement between plaintiff and YouTube. That, well, number one, that's clearly not going to be the case. But number two, it's not clear in any of his voluminous complaints. So that's just bad. So continuing. Plaintiff has brought this copyright infringement action against YouTube users that are committing wholesale copyright infringement of plaintiff's creative works. YouTube has been joined as it is at least partially liable for its failures to abide by the Digital Millennium Copyright Act, DMCA. In violating the DMCA, YouTube has lost any safe harbor protections that it would normally have under the Communications Decency Act at 47 USCS Section 230. Just no. He says they're committing wholesale copyright infringement of his creative works. But they're not. So, a little spoiler. He's going to allege that his copyright claim is based on a video that isn't on YouTube. Except, for starters, he hasn't pled that. And number two, the video in question, which I'm not going to spoil yet, was clearly fair use. So it falls apart on multiple levels. So if Kate and Josh have not committed copyright violations because all their videos have been fair use, then YouTube can't be at least partially responsible for failures to abide by the DMCA because, well, they're not. They have done the necessary steps in the DMCA safe harbor, which is they have the copyright claim system, which has the claim, counterclaim, and then put up or shut up by suing. And YouTube is able to, in good faith, say, yeah, we've looked at this and we think it's fair use, so we're going to keep the video up. That's what they did. And now Delete Lawz gets even more ridiculous. Although YouTube interprets their terms of service agreement between plaintiff as the plaintiff promised to pursue all federal litigation regarding the service exclusively in the Northern District of California, the actual terms say otherwise. I mean, clearly Delete Lawz knows how to interpret YouTube's terms of service better than YouTube itself. The TOS defines service as the products, services, and features we make available to you as part of the platform. The TOS then goes on to say, all claims arising out of or relating to these terms of service will be governed by California law, except California's conflict of laws rules, and will be litigated exclusively in the federal or state courts of Santa Clara County, California, USA. You and YouTube consent to the personal jurisdiction in those courts. This makes it clear that the forum selection clause in the TOS and TOS itself only apply to claims between users of the service and YouTube related to the products and services that YouTube provides the users, not to all claims related to YouTube. YouTube's wild interpretation would require anyone who's ever watched a YouTube video be bound to bring all claims against YouTube in accordance with the forum selection clause in its TOS, regardless of whether the claim arose due to its service. Well, that's a poor argument. It's a very poor argument because Delete Lawz isn't a mere user. He doesn't just watch videos on YouTube. Number one, he created a YouTube account where he affirmatively accepted the terms of service. So that's strike one in his, well, in Google's favor. He doesn't simply watch videos without an account. This argument might fly if I'm watching a video on a computer that has never logged in to Google, never logged into YouTube. But he's not in that position. And what's more is he's agreed to it twice because he's a part of the YouTube Partner Program. So this is disingenuous. And it's especially disingenuous for reasons we'll see later. But YouTube then cites many cases related to parties suing YouTube for the services it provides, which are irrelevant here. The instant action is actually like Viacom versus YouTube from the Second Circuit in 2012, where YouTube did not argue that its terms of service applied, and rightly so. Viacom's action was related to YouTube's failure to take appropriate action for copyright infringement on its platform. Viacom had arguably used YouTube in order to see that there was infringing content on the platform, and therefore arguably had agreed to the TOS. But arguably, Viacom was not uploading videos to YouTube. It's almost like he's arguing that this is victim blaming. He's saying, well, because here's what I haven't looked at Viacom versus YouTube, but here's what it's going to say. It's going to say that Viacom is CBS and Comedy Central and various others. So they're going to say that, I'm just going to say South Park because I can't think of a CBS show, frankly. I don't really watch CBS much. But, or, well, let's say college football that was broadcast on CBS was uploaded by a random channel to YouTube. And CBS did not create an account to upload college football to YouTube. In fact, they don't have an account to upload any of their content to YouTube. So any Viacom property that is on YouTube was uploaded by someone else, whether it's just complete copyright infringement or actual fair use. So you upload a college football game and in its entirety with no commentary, it's obviously a copyright violation. And YouTube doesn't immediately flag it and bring it down. Viacom has not agreed to the terms of service to put their content on YouTube. So they're not bound by the terms of service. It's that simple. Delete Lawz has. But he gets even more ridiculous. YouTube is not a necessary party in this action under Federal Rule of Civil Procedure 19. And so its forum selection clause would be unreasonable, citing C. White Marine Inc. versus S&R Corp., which is a Massachusetts case from 2013, which cites Fred Lurie Associates versus Global Al Associates Inc. From the Southern District of Florida in 2006. But YouTube isn't a necessary party in this action. But it was Delete Lawz who chose to drag Google into this action. He dragged them into court. He can't then complain, well, they don't really need to be here, so their terms of service don't matter. It doesn't work that way. He dragged them into court, therefore, the terms of service obviously matter. The terms of service would also apply if Google were to sue him for all of his false copyright strikes. If they were to drag him into court to get an injunction to get him to stop false flagging, I mean, they wouldn't. They'd just boot him off the platform first. But if Google were to sue Delete Lawz, it would also be in the Northern District of California. If they were to sue me for some reason, it would be in the Northern District of California because I've agreed to their terms of service twice. It's just that simple. YouTube was joined in plaintiff's supplemental complaint because in a related action occurring after plaintiff's first amended complaint, YouTube acted in violation of the DMCA, allowing its users to keep infringing content on its platform and accepting at least partial liability. Even if YouTube's terms of service applied for a forum selection clause, YouTube was added later and is not a necessary party. A forum selection clause only prevents a party from arguing against using that forum for its own convenience. What? A forum selection clause only prevents a party from arguing against using that forum for its own convenience. What? Oh, I reading the next sentence, I think I get where he's going. But it doesn't make sense. Still. Here, plaintiff argues for the convenience of the necessary parties, especially the named defendants Catherine Peter and Joshua Abrams, who reside in or around Massachusetts. Additionally, this court doesn't allow for changes of heart. Judge Burroughs is going to annihilate him. He put that in italics. Number one, this isn't about Delete Lawz having a change of heart. This is about Google enforcing its terms of service. But as Google pointed out, Kate and Josh also agreed to the terms of service twice each. So they have agreed that any litigation involving Google can take place in the Northern District of California. But the court can sever and send Google to the Northern District of California while keeping Kate and Josh. That's an option. But it's not for Delete Lawz to argue that point for them. Kate and Josh are fully capable of making their own arguments about their own convenience. This isn't Delete Lawz white knighting for them. It's absolutely ridiculous. And like I said, he's trying to argue Kate and Josh are necessary parties, but Google isn't. Except he's the one that yanked all of them into court. If you drag someone into court, you're saying they're a necessary party. He's the one that did it. It was all him. But as we're going to see, I kind of doubt that Josh Abrams is even a necessary party anymore, at least based on his own argument, from what little I have read ahead. Because to my knowledge, and I could be wrong, Josh hasn't committed the agreed upon copyright infringement, apparently. At least I don't think. But I also don't watch Josh's videos, so. But apparently, circumstances have changed. YouTube cites Atlantic Marine Construction Co. versus United States District Court, Supreme Court case from 2013, and Atlantic Marine cites the Bremen versus Zapata Offshore Co., also a Supreme Court case from 1972, which goes on to explain that the court drew a distinction between a situation in which parties contemplated the alleged inconvenience at the time of the agreement was the time the agreement was negotiated, and a situation where the inconvenience is a result of circumstances which were not present at the negotiation stage. Not knowing that YouTube would violate the DMCA and add itself to this action after it was filed would clearly apply. That's his whole argument for circumstances have changed. Copyright law hasn't changed since then. The DMCA wasn't added since then. YouTube has had its strike, counter-strike notification system since well before this litigation started. YouTube hasn't violated the DMCA anyway, so that's irrelevant. YouTube didn't add itself to this action. Delete Lawz did. If I remember from reading the complaint or from the motion from Google, the current version of the TOS that Delete Lawz agreed to are from 2019, thus before Delete Lawz even joined YouTube as a creator. So, and he cites Brayman versus Zapata offshore, where the parties contemplated the alleged inconvenience at the time the agreement was negotiated, and a situation where the inconvenience is a result of circumstances which were not present at the negotiation stage. Give us what changed. What changed that made it so that the court agreed that the circumstances had changed? Give us a reason to believe this. The problem is there isn't one. So, but apparently the burden is on YouTube in showing why there is good cause for the transfer. The burden, without even reading this, the burden is on Delete Lawz to show why the terms of service don't apply to him. He's engaging in burden shifting, which we all know that sovereign citizens love burden shifting. It's if sticking with sovereign citizens, jurisdiction, there's a rebuttable presumption of jurisdiction if you were arrested for a crime in that jurisdiction and you're alleged to have committed that crime in that jurisdiction. So, like, the traffic ticket is prima facie evidence of you committing a crime in that jurisdiction. The burden is on you to show that there is no jurisdiction, that the court does not have jurisdiction over you or over the alleged crime or whatever. But they're saying, well, the court hasn't shown it has jurisdiction over me. But it's a rebuttable presumption, meaning it's his burden to show. In this case, Delete Lawz is trying to do the same thing. The presumption is, and as the case law that Google cited in the last motion, it's a very high burden to overcome. The presumption is that the terms of service apply to him and that the forum selection clause in the terms of service apply to him. It's his burden to show that it does not, but apparently the burden is on YouTube in showing why there is good cause for the transfer. The good cause is the terms of service that he agreed to. But only when a forum selection clause is free from fraud, influence, or overweening power, whatever overweening means, or overweening bargaining power, does the burden shift to the other party. Here, plaintiff does hereby declare that YouTube had superior bargaining strength and that plaintiff only had the opportunity to adhere to or reject the agreement. BABN Tex Corp versus Bruno from the Eastern District of Pennsylvania in 1998. he's trying to argue that the terms of service are a contract of adhesion, where the stronger party, in this case Google, says, here's our terms, this is the contract, take it or leave it. And he couldn't even find something from the First Circuit or from the Supreme Court or the District of Massachusetts. He had to find the Eastern District of Pennsylvania. I guarantee there's got to be at least one case on contracts of adhesion out of the District of Massachusetts or the First Circuit. I guarantee there's a case, but it's not going to apply here. They didn't force him to sign up for Google. That this is a general contract that they say, if you want to use our service, great. Here's the terms. If you don't want to use our service, fine. Go to Twitch, go to TikTok, go to Rumble, go to Twitter, go to Instagram, go to Facebook. He'd have a much higher bargaining power, a much stronger position if YouTube were the only platform on which he could share videos. He could make his own website and share videos on there. But he doesn't. He wants to take advantage of the reach he gets from Google, off of the hosting power of Google and YouTube. He wants to take advantage of the Google search engine. YouTube is the second largest search engine in the world, second only to Google. He wants to take advantage of all that the service has to offer, but he doesn't want to be held by the responsibilities that come with that. It's, as we always say about sovereign citizens, it's rules for thee, but not for me. In fact, well, I don't have it pulled up, and it'll take what little bandwidth I get in this room that I use as my studio foolishly. But in the DeCastro versus Wagner case, the most recent filing from, I'm not sure if it's the Lawrence County defendants or the Ironton defendants, they didn't say rules for thee but not for me, but they said it. They said DeCastro wants the full protections of the court, but he doesn't want to follow the rules of the court. He refuses to accept service by email, even though he has to, since he's, at least now, has ECF access, but he also is clearly not monitoring the mailing address, and he comes to us multiple times after default saying, well, I never got it, but he's not monitoring the email, the physical mailing address, so he wants it both ways. And that's just the case. But moving on. Additionally, even where not unconscionable, the significance of a forum selection clause in a boilerplate agreement is greatly reduced, citing Nee Theater Corp versus Eddie and Eli Landau, Inc., from the District of Massachusetts in 1983. Google's terms of service are not a boilerplate agreement. They were not created specifically for Delete Lawz, but that doesn't make it a boilerplate agreement. They are carefully crafted for users of YouTube. They are not created for users of YouTube and MasterCard and Disneyland and shoehorned all to fit every service imaginable. It's for YouTube. It's not boilerplate. It's just ridiculous. And then moving on from his arguments against the transfer to the 12b6. And this is bad. This is really bad. Plaintiff has not made copyright pleading failures and should be allowed to amend its complaint. He has failed to sufficiently plead copyright, period. And the court has said, we're going to be a lot more strict about granting more bites at the apple. The apple is at its core. There are no more bites except for very good cause. In fact, let's take a look. Damn it. I mean, darn it. I closed the docket instead of clicking to the docket. And I don't want to use the bandwidth to open it again. But either way, Judge Burroughs said the court will be much more demanding to get another amended complaint. But as we've said, he wants to amend and amend and amend and just keep it in the amended complaint merry-go-round because he's terrified of discovery. As we've seen, like I said, I haven't been covering the Ironton case, but in trying to get some discovery from him, we've seen how he freaks out at the mere prospect of discovery. Well, I don't have to provide any of this because I'm not alleging injury or loss of income or this or that or that. It's like, well, then you're not alleging any damages, period. But as I said, he has failed at every level to sufficiently plead copyright because, like I said, in order to make a bare bones, absolute bare bones copyright claim, you have to say, this video from the defendant violated my copyright in this video because he has not done so in any of those complaints, amended complaints, or supplemental complaints that we looked at. None of them. He has said, here's a list of my videos, of the URLs for my videos. Here is a list of their videos. Nowhere has he said, this video violated the copyright in this video. Nowhere. So that alone means he has not pled sufficient to the Twombly and Iqbal standards to survive a 12b6 motion. But also the registration requirement. But we'll get to that. So Although a copyright claim can be dismissed for not having alleged that the copyrights have been registered in accordance with the statute, if raised, a copyright claim only requires two elements: ownership of a valid copyright and copying of constituent elements of the work that are original, citing Feist Publications Inc. versus Rural Telephone Service Company from the Supreme Court in 1991. Here, YouTube has joined the party a bit late, and the other parties never raised the issue. They have. They have. They have long pending motions to dismiss. They submitted their motions to dismiss in January, or maybe even late December. But those were put in Judge Burroughs' drawer to wait until he filed his new supplemental complaint, or as she put it, amended complaint. That they made the argument. They made the argument that he had an alleged copyright. Period. And I'm pretty sure they also, at least one of them, raised the issue of failure to register the copyright. But here's the thing. He says a copyright claim only requires two elements: ownership of a valid copyright and copying of constituent elements. Well, those are the elements, but you have to plead those. Their mere existence doesn't mean you win. You have to sufficiently plead those elements. Ownership of a valid copyright, he has to show, I own a copyright in this work that is registered with the U.S. Copyright Office. They violated it with this video because this section of their video contains my work and they didn't provide commentary. It's not transformative, blah, blah, blah. Therefore, it's a copyright violation and I should win. He hasn't done that. He has failed to sufficiently plead. Plaintiff does hereby declare that it has successfully and completely registered at least one key video in its complaint, and the registration can easily be found by searching the public catalog at loc.gov. That's libraryofcongress.gov. Even though you'd search at copyright.gov. But I know this is going to blow your minds. It is not the burden of the defendant to search for the copyright registration in order, or for the court, for that matter. It is not the job of the court to search for the copyright registration in order to complete an insufficiently pled complaint for copyright infringement and say, well, I searched out the missing information. I searched it out. I found it. Therefore, motion to dismiss is denied. No, it's the job of the plaintiff in the complaint to say, I registered the copyright for this specific video with the Copyright Office. Here is evidence of that. Here's my exhibit where I show that I registered before instituting the copyright action. Remember, you have to have the copyright fully registered, not just applied for, but fully registered before you sue. He has not done so. Nowhere in his complaint has he shown that he had one registered. So, that being said, I told you the dates would be important. He does actually now have one registered. You may even remember the important date I gave you, February 2nd of this year. He registered it on February 2nd. The only complaint that came after February 2nd was the supplemental complaint, the second supplemental, the April 24th. He sued YouTube before that. He sued Josh and Kate before that. So Google is right. He did not have none registered before instituting the action. Thus, the action fails. It's that simple. But he is a moron. Finally, plaintiff did not license its videos to YouTube for any use. The key video in this litigation was never published on YouTube. This is what they call in law school hiding the ball. And they tell law students, don't hide the ball. If the court has to guess what you're talking about, it's not going to. You fail. But the key video in this litigation was never published on YouTube. He hasn't told us what the key video is, even here. When it comes to videos, he has just given us interminable lists of URLs of his videos. And I checked those lists of URLs before going live, both at the Appendix A submitted with the April 24th supplemental complaint, but also the list of URLs from the amended complaint of November 16th. Every single one of those URLs is from YouTube. Every single one. So he has not pled any infringements that were not of his YouTube videos. Ever. This is the first we're hearing about it in his opposition to the motion to dismiss. So how can he say he has sufficiently pled a copyright violation to an unknown video that is not in any of his complaints? That this is the first time we're hearing about it. You can't say in your opposition to the motion to dismiss, this is what I really meant to include in my complaint. Except he doesn't even do it here, as far as I know, because like I said, I haven't read it fully, but he just says the key video, not this video, this specific video. It's the key video. What's the key video? I know what the key video is, by the way, but we're going to keep reading first. Also and again, plaintiff's complaint is against YouTube allowing its users to infringe on plaintiff's content. The TOS does not allow for this, and clearly the related license only allows those users to play back or embed the content. Emphasis added. YouTube also grant each other user of the service a worldwide, non-exclusive, royalty-free license to access your content through the service and to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it only as enabled by a feature of the service, such as video playback or embeds. For clarity, this license does not grant any rights or permissions for a user to make use of your content independent of the service. Conclusion. Since both parties stipulated to joining YouTube in this action due to YouTube's actions, and the court granted that motion, it would be surprising to see YouTube's dismissal or transfer granted based on their weak and boilerplate arguments that are reused every time someone sues them over their TOS. It's almost like it's because all of the users have signed the TOS. And if they don't sue in the right court, YouTube uses the TOS to get it transferred. YouTube should at least be required to read the complaint and plead relevant arguments. This is such unearned snark. If YouTube is dismissed from this action, it will just add the possibility of the remaining defendants to make third-party complaints against YouTube for being liable to those defendants for all or part of the plaintiff's claims against those defendants. What? He's trying to argue the court should not dismiss the claims against YouTube because if YouTube is dismissed, then Kate and Josh can sue YouTube for Delete Lawz claims against Josh and Kate. First of all, that would be frivolous, wholly frivolous. But second of all, he's trying to argue the position between other parties to benefit himself. That's not how it works. It would actually be convenient for plaintiff to have this action transferred, but plaintiff certainly did not agree to a relevant forum selection clause that would require it. Even if plaintiff did agree, exceptional circumstances exist that would make it unreasonable, especially for the other parties. Plaintiff prays that this court deny both of YouTube's motions. So, I thought there was another argument in here, but it's not. I could have sworn I saw it on Kate's Discord in the Chili Watch section. I thought someone had copied and pasted saying that the video in question, the key video, that he doesn't disclose what the key video is, but that it sounded to me like it was uploaded to YouTube, but it was not published. So basically, he was using YouTube for storage of that video, which would mean that the terms of service apply anyway. So what is that video? It's the Hammer Boy video. It's the video where I think the video that Kate recorded, her live stream, was titled "Chili Records Himself getting arrested, or Chili films himself getting arrested, or something like that. It's the one where he had an issue with a former business partner, and he was trying to hammer a complaint about him to a tree outside the guy's house. He failed, so he had to go get a stapler to do so, and the police ended up arresting him, and it was awfully embarrassing. So, how did Kate get the video? Delete Lawz sent it to photography is not a crime, or what, photography isn't a crime, pho- whatever the group is. Basically, he sent it to them thinking he looked good in it and that the cops looked bad in it. They laughed at him and they sent it to Kate. I think it was Felipe Hemming specifically. I'm not sure. So I'm saying I think. But presumably he granted that organization a license. He didn't, I doubt he specified this is for your use only. You may only put it on your website or your YouTube channel. It's almost like this was a sub license, which I'm not saying is valid necessarily, but let's say he uploaded it onto YouTube as an unlisted video, which, if a video is unlisted, you can send the link and access it, but only by affirmatively pressing the link, the direct link. So let's say he did that and he sent that link to PNAC, and they sent the link to Kate, so she accessed the unpublished video on YouTube. So YouTube's terms of service apply. It was fair use anyway. So he loses. But like I said, he claims he registered at least one key video that can be found, except he doesn't say which key video, so he fails. He should be used to being a failure by now, but I just want to emphasize once again, he fails. So with that, that was maddening. That was inane. That was definitely Delete Lawz that wrote this, not one of his lackeys. You can tell when he writes it. It's just bad. So with that, thanks for joining me. Do all the YouTubey things, like, share, subscribe, bribe your friends and family to do the same, and I will see you soon. Bye-bye.